So that brings me to another point of interest for people who actually practice. For people who practice, they ask me all the time, assessing prospective applicants, where to start, what to do. Well, let me share it. If you can use it for your own practice, by all means, go ahead. Eliminate red flags. And you know what red flags are. You have to be very, very careful about those, because later on, it will bite you. It will kick you in the butt and definitely will make your life miserable. Trust me, it will happen. If you ignore them, they will come back. Inadmissibility. Why don't you check medical, criminality, misrepresentation factors from the past? Are they admissible? Because you can spend a lot of time and a lot of money, and clients may spend a lot of time and money before you actually identify, oh, this person is medically inadmissible. Why don't we talk about significant demand or clear-cut inadmissibility? Criminality. What if we have to go through rehabilitation? What's the point to invite investors to participate in a company if the person of interest or applicant, in any case, cannot even immigrate to Canada for the next 5 years or 10, depends on the criminality charges. So you have to address that before you even accept the client for this program. Misrepresentation. People say, how can you find if people lie? Well, easy. You have to ask them straight questions. Build a line of questioning that people have to respond, and you have to listen. Because people sometimes accepting clients and saying, well, whatever happened later. Yeah, some bad lawyers, bad consultants, unfortunately, do that. I see situations when people come and say, well, I was rejected for misrepresentation. Oh, my lawyer never ordered capes, notes, AT file, GMSM files. We never bothered to do that. I said I applied before. Well, they just let me apply this time without checking the past. And you know, the biggest reason for RCC to reject these days is misrepresentation. Misrep is harsh. Since 2018, it's 5-year ban, and there is no appeal. Of course, you better check it before you start. So that's one of the assessing points. The next one is financial ability to sustain the requirements of the program. Settlement funds. Well, people have to present 6-month statements before they apply of personal account. And people say, yeah, we have it. Why don't you check? And if you check and they don't have that, why don't you address that issue? Because the certification process may take 3, 4, 5, 6 months, and then certificate is valid for 6 months. So you have time if you address it now, because when you address it later, it's too late. That's what we call, if you found yourself like, 10 meters from Niagara Falls, you're done. It's over. Okay, so if you found that they're not ready, when you actually have certificates on hands, you have 6 months and you don't have enough time to even build the history, right? Legal fees. Please make sure they can cover your fees without denting into their settlement funds, because they can say, yeah, I have $12,000 for myself, $14,000 for myself, but I have to pay you, so I don't have that money. So plan carefully. Ask them for statements. Ask them for bank references, for bank letters. And last but not least, on this particular part, business co-development. At the last stage of this webinar, I give you a staggering example of comparison between PNP and startup visa participation. This is really revealing numbers, and people like my last year webinar. We have a video on YouTube directly responding to the question, what's the price element and how we compare, for example, PNP and SUV program. People have to collaborate. Investors always participate, but investors participate with partners. And if you're not able to support your partner, you're not able to participate, how can you justify your presence? And if your idea is not that brilliant, we'll cover that next. then what do you expect? Okay, so ask those questions. It's all about red flags. Innovative idea. Well, it can be anything. Despite the fact that people say, no, 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 it has to be innovative. I will talk about it. Know-how, patents, prototypes, whatever you have, you have to address that issue. What people have, how serious are they? And sometimes even ask questions like, those questions very uncomfortable. Trust me, you have to overcome that hesitation. You have to ask straight questions. People say, yeah, I have this idea. And you see that idea was developed by some institute or some laboratory somewhere in the depth of some country. You better ask, because the last thing you want to lawsuit to follow for, violating proprietary rights of that intellectual property. You better know what you're talking about. You better know what you deal. Ask your partners, ask your trademark agent, ask your intellectual property lawyer partner who will help you to address that issue and exercise your own due diligence. And related experience review. People say, yeah, Alex, you just told me there is no experience required. Yes, that's a definition. But people have to explain, and IRCC paying more and more attention. Remember, we're talking about program that evolving, that is not final yet. It's evolving. So IRCC offers us getting smarter, more trained, and more understandable. Yes, they have ministerial instructions. I believe it's number 7, but basically you just need to go through the process yourself. What experience they have, why they created the program, why they immigrate to Canada, why not other country. Maybe recently I got an example and the person started and they said, no, I'm moving to US. Well, apparently the person applied to three countries simultaneously. Can you prevent that? No, absolutely not. Can they afford it? They can do whatever they want, but you better find out. And where they got experience. Was it private enterprise? Was it state enterprise? Is there any limitation on their participation, including proprietary rights on intellectual property? Those are red flags you have to follow, guys.